to drive any motor vehicle unless you have a valid driver's license. Is that understood?
Drive, Your Honor. I travel. I'm not driving ever again in life. I travel, so I don't need a license to travel.
There's no traveling behind a motor vehicle. I'm not arguing with you, Mr. Durham. Excuse me?
I've already read the Supreme Court case law. I have a right to travel, sir.
I'm not a creature of statute. I am not under statutory law. I would demand that this proceeding take place under common law, as I am a live, flesh and blood human being, under no authority but that of God. You are here as a criminal actor.
Okay, sir. I'm gonna end the hearing now.
And I do not consent to any further hearings on this issue or this matter. We have no valid contract.
So that means I can't even go to court if I can't travel. I can't leave my house.
It's via Zoom. It's via Zoom. It's via Zoom. No traveling. The court dates are via Zoom. No traveling unless court ordered.
I have never expressed that want to her.
Why do you talk over people?
Well, I assume we were having a conversation. I'm sorry. I'll be quiet.
I am trying to have a conversation, but one's got to talk and one's got to listen.
Name, sir?
My name is Carlos Lorenzo of the family Durham.
Thank you, Mr. Durham, for your patience, sir. And on these matters, the court is scheduling a pretrial February 14th. And this is in regard to case B1245821, August 25th, 2021. No dog license. Same date, time, and location for B124582221, August 25th, 2021. Failed to vaccinate dog against rabies and or provide proof of vaccination. 3 additional matters. One at a time. State your full name, Mr. Durham.
Lorenzo of the family Durham.
Here. For waive formal reading and or plea of not guilty. Mr. Durham, the court scheduling a pretrial date on this matter via Zoom. You must attend February the 27th, 8:30 a.m., 36th District Court in front of Judge Bryant. Understood?
I hear you.
And this is a very serious non-assaultive allegation, Mr. Durham, and the court has concerns that you missed a court date on this matter, as well as 2 other matters that we're about to handle. And your capious history, Mr. Durham, tells the court you do not listen to the court as ordered to appear, and that's concerning where if the court were to release you on another personal bond, sir, you treat it as you have in the past and disregard court's orders and simply not appear. And that's unacceptable, Mr. Durham. You must appear as ordered. So the court, based on your capious history, take into consideration the information presented by counsel, including that limit to employment status as relates to the ability to post bond, the nature of the charge, as well as the information alleged in the investigator's report, is setting, based on your capious history, is going to continue the bond set by Judge Bryant of 110%. Is that an affordable bond?
It's not.
Okay, so on that matter, the court is setting an unaffordable bond redetermination hearing. During this bond, you are not to purchase or possess a firearm or any dangerous weapon, and you are not to drive any motor vehicle unless you have a valid driver's license. Is that understood?
Drive, Your Honor. I travel. I'm not driving ever again in life. I travel, so I don't need a license to travel.
There's no traveling behind a motor vehicle. I'm not arguing with you, Mr. Durham. Excuse me?
I've already read the Supreme Court case law. I have a right to travel, sir.
Okay, well, I have a right to impose bond and conditions of bond, Mr. Durham, and I'm telling you, whether you call it traveling or driving, there's to be none of that behind a motor vehicle. You're not to travel if you're operating a motor vehicle or drive. No driving or operating of a motor vehicle, regardless of what you call it. Understood, Mr. Durham? No driving or traveling if you're the operator. Is that clear? And you're not to leave the state of Michigan. And that's no driving, period. That's regardless of your license status. There's to be absolutely no driving. Or traveling. Okay, I said no traveling either.
Driving is up.
No traveling. Just put that as a bond. No traveling.
So that means I can't even go to court if I can't travel. I can't leave my house.
It's via Zoom. It's via Zoom. It's via Zoom. No traveling. The court dates are via Zoom. No traveling unless court ordered.
That's a violation of my rights. And I will appeal this in a higher court.
Did you want to address his traveling, counsel?
I'm sorry.
Did you want to address his argument that he can't, that he can travel?
He's going to comply with court orders.
And that means no driving and no traveling. Is that correct, counsel? No traveling unless court ordered. Yes, I can't leave the state of Michigan, and he cannot drive or travel, which my understanding is him operating any motor vehicle. Is that understood? Thank you. Okay, Mr. Durham, this is a very serious allegations. Again, you have a capious history on this matter. The bond was set by the judge when you failed to appear. You have a number of capious histories on this matter. It looks like you were originally given a personal bond, then you failed to appear on about September 1st of 2022, given a 10,000 cash surety, and then you failed to appear again December 14th of 2022, and then a judge will give you another 10,000 cash surety. I, as a magistrate, as counsel stated, have no. One moment, I'll let you address the court. One moment, Mr. Durham. Have no authority to amend the capious bond as set by the judge for your failure to appear. So for that reason, the bond is going to be continued as set by the judge of December 14, 2022 in the amount of $10,000 cash surety. During this bond, you are not to purchase or possess a firearm or any other dangerous weapon. No driving, no traveling unless court ordered. You will be fit with the GPS tether under house arrest if you're able to make bond, and no use of any alcohol or illegal controlled substance. Is there anything further, counsel?
I would respectfully ask the court to reconsider the GPS tether, Your Honor.
He's missed court in every matter before the court this morning, so no.
Thank you.
You're welcome.
No, I haven't.
Anything?
I done came to court a couple times on Zoom, on a tether. I done been to court.
But not all of the times it does not appear, Mr. Durham. It looks like you've missed court more than once on that matter that we just handled. Anything else on this matter, counsel?
On account of the county jail. I missed court on account of the county jail. They wouldn't take me to court. I missed court because of the county jail would not take me to court. That's not my fault.
And Mr. Durham, the court has the same concerns, sir, that you've had a capious on this matter as well as the matters before the court previously, and that demonstrates to the court that you failed to appear as ordered, and that's concerning regarding your intention to appear and handle this matter. It looks like you're on a personal bond by the Honorable Magistrate Ramsey Heath, where you failed to appear on or about December 14, 2022, and a bond was issued at 10,000 cash surety. I, as a magistrate, have no authority to change that bond as set by the judge. So the bond is going to be continued, taking into consideration any employment status presented by counsel as it relates to ability to post bond, as well as your capious history. During this bond, no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any other dangerous weapon. If you're able to make bond, you will be under house arrest, fit with a GPS tether prior to release. There's to be no driving and no traveling unless court ordered. Okay, any questions or statements, Mr. Durham? You are being recorded. Anything you say can and will be used against you. And on that matter as well, you're getting an unaffordable bond redetermination hearing on January the 19th, 2023. Judge Sabri at the 36th District Court via Zoom. Do you have any questions or statements, Mr. Durham?
Yes, I do. This question is to you, the magistrate. Are you honoring your oath?
Before you say anything,
This is your turn.
everything you say right now kind of will be live or on YouTube. Please do not say anything right here. I would like to actually, because I try to protect you, okay?
That was your attorney speaking and giving you advice.
Are you honoring your oath, sir?
I don't know what type of question that is, Mr. Durham. Do you have your counsel has indicated you have a right to remain?
Now you don't know what it means. You took an oath to uphold the Constitution, didn't you? Are you honoring?
I don't know what the purpose. I don't know what the purpose. I'm not here to answer your questions. I can tell you that, Mr. Durham, as far as regarding questions that don't have anything to do with the arraignment. I'm not here to just answer random general questions that have nothing to do with your arraignment, Mr. Durham. So if you have any questions regarding the court date, you can please let me know.
I want to know who you are. You won't tell me your name. You won't tell me if you're bonded. You're a public official. Are you bonded?
Mr. Durham, I'm not going through. Mr. Durham, I'm not going through that. The nature of my employment.
You got to give me your bonding information, name, address, and your policy number so I can make sure you're adequately insured. Just in case you want to violate my rights, I got to make sure you're adequately insured. Are you a public official and are you insured?
My name is Chief Magistrate Winfrey Coulter. I've answered that question regarding binding, Mr. Durham. That's not something that's going to be addressed today.
So you're not going to put that on the record?
I'm just not entertaining a question that makes no sense during the arraignment, sir.
It makes no sense to ask you if you're bonded. And what's your bonding
If
information?
that
That
makes
don't
you
make no
happy,
sense.
Mr. Durham. I'm bonded if that makes you happy, Mr. Durham. I do have a valid bond as indicated by statute. Mr. Durham, I'm not getting back and forth. Counsel, do you have anything further with Mr. Durham?
Number of the bonding company. Can I have any of that so I can contact them? I got to be able to contact them.
No, Mr. Durham, I'm not. I gave you, I let you know I was bonded. My name is Chief Magistrate Coulter at the 36th District Court. That's the information. Okay, Counsel, we can try anything further. Mr. Durham, I've said more than once, we're not going through that here today on the record. So, Mr. Durham, if you have any questions about your arraignment or court date, otherwise, we're through with the arraignment. Counsel, do you have anything further?
To give me the name of the bonding company.
Unless you have anything else, Mr. Durham, we're through with the arraignment.
Amazing.
All right, Mr. Lockart has a note here on one of these tickets. Did you send a note to the court, Mr. Lockart?
Yes, I did.
Did not accept your offer to contract and do not agree to these proceedings. All right, so what do you want to do?
I'm here under threat, duress, and coercion. I'd like to say for the record, my name is Jamal of the family Lockart.
Let's get the record established. This is the city of Detroit versus Jamal Amir Lockart. Appearance for the record, please, Counselor.
Rita White, House Counsel, on behalf of Mr. Jamal Lockart.
All right, Mr. Lockart.
No one is representing me on my behalf. I don't know that.
All right, go ahead, Mr. Lockart.
Yeah, so I am Jamal of the family Lockart, flesh and blood, living man, and attorney in fact for Jamal Lockart and Legis Trust. I'm here by threat, duress, and coercion. I'm here making a special appearance. And I'm here to demand that the court prove jurisdiction over me as a live flesh and blood man. As I said, I submitted a challenge to jurisdiction. Jurisdiction must be proven and proven on the record. And then also I submitted Freedom of Information Act request for your foreign registration statement and anti-bribery statement, as well as that of prosecutor. There is no contract. Every presentment that was made to me was formally rejected and sent back to the court, which is what you have a copy of, by my notary. I do have a live witness notary who can come in and testify to that fact. Given that there is no commercial contract, no commercial agreement, I fail to see how the court has jurisdiction. Furthermore, there's been no injured party, and no, there's been failure to state a claim through a verified affidavit. So if someone can prove to me how this statutory commercial court has some kind of jurisdiction over me as a live flesh and blood human being, I think we could start there.
Well, let's start here. You have a notice is not what you think notice should be. Notice is what is if it's properly effectuated in the courtroom. And I'll certainly give you whatever hearing that you want if you file the proper motions and material to contest that. I'll give you an opportunity to be heard on that. But furthermore, what I'm looking at is I have a proof of service.
There is no proof of service that was rejected and sent back to the court. You have a copy of that.
You're not even listening. You're not even going to listen. I listened to what you said. Are you going to listen to me?
I am listening to you. I'm just responding to you.
All right. So why don't you listen before you start making statements?
Oh, you had paused. I thought you were finished.
What it isn't.
Well, go ahead.
Are you giving me permission to go ahead now too, right?
I assumed you were done speaking.
All right. Listen, I have an envelope with certified mail. I don't know I believe the contents have been stapled to the envelope. It's got a proof of service effectuated by Nyla Perrin. I have a signed complaint here, signed by Officer Randy Randolph on 11/19/2019.
Is he here today?
And we can get him in here. Today is only date and time is set for arraignment. So you're just being arraigned, and what the arraignment purposes of your arraignment, and let's go through the whole thing, is you're here for a expired plate ticket. That is a civil infraction that carries a $145 fine. There's an allegation that you did not have a drove while license not valid or improper. That is a misdemeanor offense, punishable by 93 days in at the maximum by 93 days in jail and or $500 in fine. On the same day and time, it was an allegation that you did not provide proper insurance. That is a misdemeanor, as it's written here, and that is punishable by the maximum possible penalty of 93 days in jail and or $500 in fines. There's also a warrant for your arrest for an allegation of an improper, not valid driver's license. So today is the date and time set for arraignment. You have the option of pleading guilty, not guilty, or standing mute. You stand mute, I'll enter a not guilty plea on your behalf. What would you like to do, sir?
I am here under threat, duress, and coercion to demand
You're
that
not
this
here under threat, duress, or
prove some kind of jurisdiction. And until jurisdiction has been proven, we can go no further. I would also like to ask you, is this proceeding taking place under common law?
This proceeding is taking place in accordance to the court rules and the statutory laws of the state of Michigan.
So I am not a creature of statute. I am not under statutory law. I would demand that this proceeding take place under common law, as I am a live flesh and blood human being, under no authority but that of God.
All right. I'm not going to go back and forth. I'm going to give you another court date. I don't have any All
I need you to do is prove jurisdiction.
You don't tell me what you need me to do, sir. Don't do that. Just let me finish.
With all due respect, the court must prove jurisdiction.
I understand that. We can get this over with quicker rather than later if you let me do my job. What I was trying to say, you're making your claim and stating your case that the court doesn't have jurisdiction over you. In order for me to properly review that and go, it's got to be done according to the court rules. I need a motion, and I will read that motion.
I have submitted a motion to dismiss for lack of subject matter jurisdiction.
I don't have it. I don't have it in front of me. And then I'll give you a motion.
I have a timestamped copy of it if you'd like me to show you.
All right, you got to submit it to the court. Look at the.
It was filed by the clerk just 2 days ago.
Okay,
I have a timestamped copy of it.
It hasn't got to the file. I'm going to give you another pretrial date.
I would like to say I do not consent. The court has to prove jurisdiction. I filed that document a few days ago. Anything short of that is an admission that there is no jurisdiction and we have no further business. We have no contract.
Have a great day, sir.
Jamal of the family Lockart here.
Okay, you're still. Did you have a question, sir?
None other than just stating that I do not consent to these proceedings and I do not accept any contract.
You already put that on the record.
Good.
You came back in.
I would also like to ask why this Mrs. Rita White had claimed to represent me.
All right, let's go back on the record with Mr. Jamal Lockart. How old are you, sir?
I am 27.
You're 27 years old, and you go ahead and you ask why Miss White is here to represent you. Well, first and foremost,
why did she claim to represent me? And I have no knowledge.
I'll explain to you. first and foremost, she's the House counsel for this evening. So for this afternoon, she represents anybody who wants her representation as far as helping them to navigate and to defend themselves.
I have never expressed that want to her.
Why do you talk over people?
Well, I assume we were having a conversation. I'm sorry. I'll be quiet.
I am trying to have a conversation, but one's got to talk and one's got to listen.
Okay, go ahead.
You asked why Miss White said she represented you. Miss White said she represented you because she didn't know beforehand the position that you were going to take. So she's just merely
quite an
doing
assumption.
her job.
That is quite an assumption. Wouldn't you agree?
Well, by the name that you put up on there, Jamal of the family Lockart,
That is
I wasn't surprised I wasn't surprised the avenue that you were going to take on that. Just
I'm
by the
glad you
name.
recognize
But I
where
can't-
I'm going.
But she's not going to assume. I don't believe she's going to assume that she's going to treat you any differently than anyone else. And then you said that you didn't want her representation, and she.
Wouldn't you agree that for future reference, it might be better to ascertain that kind of information before she makes that kind of statement for everybody?
No.
You don't think so?
No.
So the assumption is that everyone wants her to speak on their behalf.
Yes, until.
Is that not a
until
rash
they say-
assumption?
Until they say differently, like you did.
Okay. Well, again, this whole time, there's a motion before the court to dismiss for lack of subject matter jurisdiction.
Well, there's not a motion
There has
before the
been-
court.
What has been filed, I have a timestamp copy of it. I can show you that if you need to see it. But
Okay,
your
well,
clerk
let me explain
timestamp filed that document.
Let me explain to you. And this is just for your information. You say that you filed it with the court and the clerk down at the window, and I wouldn't disagree with that. But typically you want to, when you do your filings, that's why you want to have a judge's copy, and you want to specifically have that copy hand delivered to the judge's chambers. So we don't rely on the court clerks downstairs at the windows to make sure that these files get put into the proper place. You're not going to make.
Who do you
that
rely
assumption.
on for that?
You're making, and then because you don't want to make that assumption that that file is going to get into the correct file. You don't want to make that assumption. Would you agree?
At this point, the legal issue is becoming secondary to the commitment itself. The sovereign citizen position can feel logical because it promises personal control over the process. But every additional argument increases the risk that the court focuses on compliance and procedure rather than the underlying case. That is a strategic trade many defendants do not realize they are making.
Who do you rely on to make sure that filed documents get into the right place, get into
The person that's filing it, yourself.
So it is not, you're telling me it's not the duty of the clerk to ensure that documents are filed in the case where the judge can view those documents. On my capacity, that document was sent to the court. It was sent to the court by a notary. So I do have a live witness to attest to that fact. It has also been timestamped. That was recorded as well. I have checked all my boxes when it comes to notifying the court. I've also given you a demand for your Freedom of Information Act request for your foreign registration statement and your anti-bribery statement. The idea or the fact that you do not have that is an issue, and it would mean that you are committing a crime against me and holding this statutory proceeding and trying to confuse me as a live flesh and blood man that I am a corporation beholden to the corporation which you represent. And that is my main point here today, is to tell you that I am not under your jurisdiction. I am a live flesh and blood man. You've already stated that this is not a common law proceeding. I am under no law but common law. We have no commercial contract which would enter us into any kind of statutory law.
Okay.
So I failed to see the issue. And there's also no verified complaint with a
let me stop you,
signed
sir.
affidavit.
Sir, let me stop you. And I'll let you put that on the record. I'll let you put it on the record already. We've already done those things. So, I'm gonna end it.
What you're
I'm gonna
committing
end
here
it.
is a fraud against the people.
Okay,
That's
I'm
what
gonna
you're
end it.
participating in.
okay. Whatever your position
And without
is.
without your foreign registration statement, that's an admission that you are here as a criminal actor.
Okay, sir, I'm gonna end the hearing now.
And I do not consent to
And I'm
any
gonna
further
remove
hearings on this issue or this matter. We have no valid contract. We failed to prove jurisdiction. There is no valid claim.
All right, you've
I do
already
not
said
consent.
that, sir. I've already let you make a record, and I don't want you to mention any more because I'm gonna hold you in contempt of court, okay? So I'll let you make your record.
You can do whatever you feel like you need to do. I'm here to tell you that I am not under your jurisdiction.
All right, have a great day.
What connects both of these hearings is not the original allegations. It is the court's growing concern about reliability. In the Durham matter, the discussion started with relatively ordinary charges, but the court kept returning to one issue: prior failures to appear. Once a judge or magistrate believes someone may not follow court orders, the conversation shifts from the accusation itself to risk management. Bond conditions, travel restrictions, GPS monitoring, and supervision all come from that concern. In the Lockart hearing, the court repeatedly offered a procedural path forward: file a motion, present the argument through the rules, have the issue reviewed. Instead, the focus remained on jurisdiction theories, contractual consent, and demands that are commonly associated with sovereign citizen arguments. The problem is that courts evaluate authority through statutes, court rules, and established precedent, not through whether a defendant personally agrees with them. A pattern appears in both cases. Each defendant is trying to challenge the legitimacy of the process. The court, meanwhile, is evaluating whether the defendant will participate in that process at all. Those are two very different conversations, and when they happen at the same time, defendants often lose ground without realizing it. The larger consequence is not always an immediate conviction or ruling. Sometimes it is the gradual loss of credibility. Once a court begins questioning whether orders will be followed, every future decision, bond, scheduling, supervision, and sanctions is viewed through that lens. And in hearings like these, the most important turning points are often not the accusations themselves, but the small decisions that shape how the court views the person standing before it.